No, I'll start actually with the
No, start with the heart. Let's just go.
Okay, how do you sue the government?
Something that people don't often know is that you can sue the government. The government is required to follow laws just as any of us, and if they're going beyond what is permissible by laws, you can challenge those actions.
We do a lot of suing the government, and there are different ways to do it, but one of the most important and most used ones is something called the Administrative Procedure Act. We love the APA at Democracy Forward. The APA basically says that agencies can't break the law and they can't just do something because they feel like it.
So if you are trying to challenge something that the government has done, you can bring it under the APA. And it can be set aside if it's arbitrary, capricious, or contrary to law. If something is arbitrary, it means it lacks reasoned decision-making. Capricious, it's similar to arbitrary, is that it's not unfounded. And contrary to law means that it was done contrary to a statute, to the Constitution, to regulation, or any other precedent like that.
As someone who's both practiced as a trial attorney and an appellate attorney, I think this is really important to understand. There's a trial court, which is called a district court, and that's where you first sue another party or you're getting sued by another party. And it's the court where you're establishing facts before a trial judge or a jury, and where you're getting the judge to be the first decider of your case. Either party who loses or gets a negative outcome from their case can file an appeal first to what's called a court of appeals. And so that's your chance to say, hey, the trial judge got it wrong. Court of Appeals, can you please look at this? You're limited to the same record that the trial judge looked at, and we want you to examine the legal issues because we think the trial judge got it wrong. The last step that they can ask for intervention in is the Supreme Court. So there's the trial level where the facts are finally hashed out, then the appellate level, and finally the Supreme Court level.
The shadow docket is sort of like a spooky term. And it's a spooky term because it's a really important thing that's going on and there's not a lot of transparency into it. It refers to the court's emergency docket, which technically has been around for decades, but has gotten a lot more important and a lot more active in the last couple of years. Basically, the emergency docket is intended to handle really unusual, exceptional circumstances where the Supreme Court needs to intervene and pause a decision of another court. It's been used a lot more frequently lately, especially with challenges to the Trump administration's actions. The Supreme Court is deciding temporarily huge questions of national importance, and the parties and the public aren't getting any explanation for why.
It really depends. Even if the entire proceeding is adjudicated and done, it could be appealed, which means that a higher court would then look into the matter and look at the legal reasoning behind it. There are also ways for parties to make sure that the other side is actually doing what they're supposed to be doing under the court's orders. So even if a matter is done, there's still activity that happens afterwards.
If you have other questions, we'd love to hear them. Leave us a note in the comments.